Hi, how are you? My name's Hugh Reed. I'm the founder and CEO of Reed Bar Review. And a couple of things you need to know about me. Number one, in my younger years, I was an Army Ranger. In my later years, I was in charge of aviation training for the Army. And Rangers and pilots have one thing in common. They love acronyms, they love memory devices. And so should you, because if you remember the most often tested concepts and elements of these concepts, you're able to get most, if not all, the points with your analysis on a bar exam question. And of course, for multiple choice testing, I've taken and passed well over 30 multi-state bar exams, so I have a little bit of an idea as to what's relevant these days, and I can cut right to the quick. So today what I'd like to do is talk to you about contract formation and some of the defenses to contract formation. You see, for contracts, we have to analyze it right up front to see whether or not that contract is a contract under the common law or a service contract, or whether or not it's a contract under the Uniform Commercial Code, the UCC. The first sentence should be, under the common law of contracts, we have some requirements for contract formation. And those requirements, in some specificity, are Q tips. We need some specific elements for contract formation. We need Q, the quantity term, the T, the time for performance, the I, the identity of the parties, the P, price, we need the price, and then finally the S, the subject matter, description of the subject matter. So for common law contracts, Q-tips, those are the elements. For a contract under the UCC, we only need the quantity term. Quantity. And in some UCC contracts, output and requirements contracts under 2306, we don't even need the quantity term. We just need good faith, all you can produce or all I can buy, all right? So every discussion of a contracts question has to start with, where are we? Are we in common law contracts land, or are we under an UCC contracts land? Now, in general, all contracts require COALL, C-O-A-L-L, C, consideration, O, an offer, A, acceptance, L, legal subject matter, and finally the second L, legal capacity of the parties. So all contracts require COALL, C-O-A-L-L. All right, once we've decided where we are, the UCC or the common law contracts, then we also have to decide whether there are any defenses to contract formation. And I remember the defenses with DUI mule. We also have the statute of frauds. I'll cover them separately. DUI mule. The D stands for duress, a contract executed under duress. The U stands for undue influence, undue influence. The I stands for illegality. The M stands for misrepresentation. The U, the second U, stands for unconscionability. The L stands for lack of capacity or lack of consideration. And finally, the E in mule stands for existence of mistake or misunderstanding. So your mindset ought to be, first of all, this is a contracts question. Secondly, is it a contract under the common law or under the UCC? If it's under the common law, it requires certain elements, Q-tips. If it's under the UCC, it requires only the quantity term, Unless it's an output or requirements contract, we just need good faith. And secondly, are there any defenses to contract formation, DUI mu, or the statute of frauds? Statute of frauds, as you remember in merry old England, where we got the common law, said, hey, all contracts, whether written or oral, are good contracts. However, some contracts are so important that a writing is required, and the defendant or the party to be charged has to have his signature on the writing. I remember the statute of frauds with my legs, MYLEGS. So all contracts, oral or written, are valid contracts. However, if you're going to sue someone under a contract and it's within one of the elements of my legs, then it has to be in writing, and the party to be charged, the defendant, has to have his signature on the contract. So what does my leg stand for? The M stands for marriage. The Y stands for year. A contract which cannot be performed within a year after execution of the contract. The L stands for land contract. The E stands for an executor's promise to pay the debts of the estate. The G in leg stands for goods, $500 or more under the Uniform Commercial Code. A sale of goods, $500 or more, has to be in writing. And finally, the S stands for suretyship contract. Suretyship contract. Or as I call it, an idiot with a pen. An idiot with a pen. You know, you come to me, hey, I want to buy a car. Can you co-sign this note for me? I say, sure, let me find my pen. I'm an idiot, all right? Because I have no good reason to sign that contract, a suretyship contract. That's why it's called a collateral promise, meaning that a person has no reason to sign the contract. If there's any reason at all, it does not fall within the statute of frauds. All right, so what are some exceptions to the statute of frauds? Because we said some contracts are so important or so unbelievable that someone would execute a contract, they have to be in writing. There are some exceptions, and I remember them with the acronym SPAM, S-P-A-M, S, specially manufactured goods. I order 1,000 bowling shirts with Reed Law Group on the back of it from Korea. They show up and I say, hey, I didn't order these. Well, that's an exception to my legs, even though there's no signature. Who else would order 1,000 bowling shirts? So specially manufactured goods. The P in SPAM stands for part performance. Part performance. So if a person has partially performed, substantially performed, why would he do that? It often arises in land sale contracts where the tenant starts renovating the property. Why would he do that if he were just a tenant, even though there's no written contract? So part performance. A stands for admission by party opponent. And then finally M stands for merchant's confirmatory memorandum under 2201. Between two merchants, you know, they talk on the phone, they agree on certain things, and one then sends a confirmatory memo of the conversation to the other. And the rule is that the receiving merchant of this memo has 10 days after receipt to respond. Otherwise, we don't need his signature on the contract. We have a contract. So, do we have a contract? Well, I don't know. Q-tips under common law, quantity under the UCC, with the exception of output and requirements contract. Are there any defenses to contract formation? DUI mule or statute of frauds. If it's a statute of frauds issue, does it fall within one of the exceptions to the statute of frauds span? So that's an overview of contract formation and some of the defenses to contract formation. Hopefully that's helpful. Go ahead and register an account or call us, 800-852-EXAM. Thank you.